Hello, everyone. Welcome back to Dr. Heinz channel. I go by the name of Heinz, and thank you so much, everyone, for tuning in. I
I
am
am
joined
joined
today
today
by
by
very special people that that go by the name of Bruce, Oregon, and Squid Pro Crow. Guys, how are you guys doing?
Oh, it's been a day, but we're good.
Doing all right.
Yeah, that's good. Um, Let's go. So today we are going to be talking about a lot of things today. But before we start, Squid, how's everything going in your world?
Long story short, TLDR, I received an email today from everybody's favorite lawyer, chaos agent, Bruce Matskin. So I'm debating what I'm going to do with that.
I couldn't let it go. I had to, I had to bring it back.
That's some breaking news. Wow.
Yeah.
And I literally just received this email about 45 minutes ago.
Oh, damn. Oh gosh. And what's going on in your world today, Bruce? How are you doing?
I'm doing all right. You know, I picked up my food for Thanksgiving tomorrow here in the States. And then tonight I've got a special champagne wine club dinner thing or something. So I'm living the dream.
That's good to hear. That's good to hear. It's been a while since I've done this type of stream with everyone, so I appreciate you guys for joining me to read this filing that David Gingras finally stomached, brush up the courage, because he's been building up to this for quite a while. Oh, I'll do it this week, but I need to finish. I need to go and type this out. I need to do this. I need to do this. He's finally done it. So we're gonna see how it fares out. But at the same time, I don't want to be sued by him for copyright. I hear that he's been going off on that. It's like, if people want to watch his content, they have to ask him for permission or something like that.
Yeah, that's specifically around his YouTube videos.
Yeah.
I think in terms of the court documents, those are fine to share and walk through. So the court documents are fine. He's really more concerned about if somebody takes his entire YouTube video and does commentary on top of it. He's concerned about that. Now, of course, everybody on YouTube already takes entire videos and does commentary on them. So
he's special, I guess.
Isn't that what YouTube is? Just taking other things that people do and commenting on them?
Yeah. Yeah, to a large extent. So, you know, he's made these statements that it's okay to share like 5 minutes or so of his videos in clips. But of course, like, he's making these arbitrary rules, which, you know, that's not how YouTube works. But anyway, I digress. The court filing is the more interesting part. What is that?
When did he buy YouTube?
Right? Yeah. I mean,
well,
yeah, he's not a majority shareholder in Google, I don't think so.
Oh gosh, yeah, like the way he is, he must be running YouTube from behind the scenes. Who knows at this point? But
he lives in an interesting world.
I mean, as far as his requests go, like, you know, if he said, "Hey, I would appreciate it if people don't use more than 5 minutes of my videos," like, I mean, I'm perfectly happy to abide by that request. It's just he starts out with threats of lawsuits rather than just, "Hey, can you know, here's my polite request."
I hate to do this since we just got started, but I have to go do mama duties for a second because something's smelly in the air.
Do your thing. do your thing. Okay. So, oh god.
It's Wednesday for you.
Yeah, that is Wednesday midweek. But yeah, this is the sample of the lawsuit, and not the lawsuit, the appeal filing that has been filed. And it starts off very interestingly. He says this case presents bizarre, interesting, frightening, and salacious facts.
Yes.
The story involves sex, celebrity, even an alleged fake pregnancy. The first thing that comes into my head is, who is he writing this script for? Like is he writing it for Hollywood?
Yeah, there's a lot of this sort of adjective-laden language, and he's not talking about he's not listing facts. He's talking about the facts, and it's very sort of editorial, and it uses a lot of subjective adjectives, right? Like he says bizarre and salacious facts. Like what scientific test do I do to determine if a fact is bizarre or salacious? Like it's very subjective, right? So that's my big problem with a lot of this document.
Let's go to a chat. Alana UK1, thank you so much for tuning in. She says, has anyone let Reddit know that you're streaming now? I don't know. I mean, you feel free to let them know if you know how to, but I don't know. I don't have any way to let Reddit communicate with Reddit.
In any case, on Reddit they'll post a link and people can watch. Even if the stream is over, people can rewatch it and things like that.
Yeah,
should be okay.
But Alana, welcome to the stream. I hope that you're enjoying yourself. Thank you so much. She says I let them know on Justice for Clayton. Thank you so much for that, Alana. But let's go back into this filing reading. It says the cost includes an inexperienced trial judge who
and that's another subjective term. Like, how do I measure whether this judge was inexperienced or not? What's the criteria? When do you stop becoming inexperienced and become experienced? This is all very subjective.
According to Dave, let me read that again. The cost again. I have to ask this question again. Is he doing this for a Hollywood script? Because the fact that he mentions the cost includes an inexperienced trial judge who apparently broke the law to ensure a Pyrrhic, I've never heard this word before. A Pyrrhic victory for a famous litigant from a popular TV show.
A Pyrrhic victory is basically like if let's say you're at war and you win the war, but you've spent all your resources, so it costs a lot to win the war, almost to the point where it costs too much. Like you get into the sunk cost fallacy and you spend too much to win a battle. That's what that means.
Basically the last 20 years.
Yeah.
At the end of the day, the strange facts of this case are almost irrelevant to this court's task, answering a very simple yes or no question. Do the rules of procedure matter, or can the rules be casually tossed aside when they require an undesirable result? This rhetorical question answers itself. Of course, the rules adopted by the Arizona Supreme Court matter, like all other statutes and regulations. Procedural rules carry the full force of the law. All judges, all lawyers, and all litigants must follow them, whether they agree with the rules or not. Well,
I don't understand why he spends 2 paragraphs talking about a rhetorical question. That seems like a waste of time to me.
Yeah, I'm wondering as well, because I don't know how this guy works. I question his motives every day. I'm being honest. But it is undisputed that did not happen here. The trial court ignored one of the clearest and arguably the most important rule of all civil litigation, and that is the safe harbor provision of Family Law Rule 26.
I would argue it is disputed, since there's going to be a respondent reply to this appeal document. So this idea that it is undisputed, to me, seems inaccurate.
And I can't wait for that reply.
Where did he learn to write this? Because I just don't understand why you would even want to say some of this stuff.
Yeah, I agree.
I don't know. My background is in medical writing, so it's like point A, point B, point C, no details.
Yeah.
Yeah, I my background's in engineering writing, and research and development, and again, yeah, it's very straight to the point.
And mine is business. We do this. We do this in business. Actually, I can definitely say from marketing, we kind of go around a bit.
If you're trying to sell someone on a Subaru Outback, you got to use some good adjectives.
Absolutely,
yeah, that's true.
Absolutely. So I can relate to where it's coming from. Actually, from my background, I do have to say, for some reason, he told me that his wife is from Luton, where I'm from. I don't know. So we have, I think, so I can connect it on two levels now. I can connect it on the family court variant of Civil Procedural Rule 11, rather than applying the safe harbor as the law requires, the trial court transformed it into the proverbial screen door on a submarine. A pointless and useless knowledge. I don't know. All of these adjectives.
It's like a movie trailer. You were right.
I know. It's actually funny how he wrote this. The obviousness of this legal error is surpassed only by the case which this court may correct it by reversing the lower court's judgment and remanding this case with instructions to dismiss the action with prejudice. Of course, this appeal raises other arguments and issues, but the court need not to reach or decide any of them. They don't. So why are you here?
Wait.
Well,
does he read this before he submits it, or does he just wing it and just hits like send?
I think he's saying if they just completely reject the original ruling, then they don't need to worry. Like at the end, he basically makes 5 requests or 5 points to consider. And I think he's saying that if the first point is made, then the rest sort of become moot. But yeah, it's written, he writes it that way before we even know what all those points are. Yeah.
He writes it in a way that just makes you go, huh? And not want to read the rest of it.
Absolutely.
Like I'm sorry. Like I said, my background is in medical writing. It's like straight to the point. But if you're gonna write a novel like this, shouldn't the first chapter be appealing and not questioning? Like, if I'm gonna write a novel, the first chapter is the most important chapter. And if you don't make any sense in the first chapter, ain't nobody gonna care about reading past it.
There's so many subjective adjectives, and it's all over the place. And I think I'd rather read Twilight. Actually, I don't know.
I don't know. I think the submarine.
Send you a copy of the Notebook.
I think the submarine door kind of grabbed my attention. After that, I would say the submarine. It hit me in the head.
There's 75 pages of this fun.
Oh, let's. Gosh.
Luckily, the introduction that matters to the layperson is only the first 18 pages or so. This is a 75-page document. After page 20, it becomes all the legal arguments, which I'm sure the lawyers are interested in reading. But you only have to go to the first 18 or 20 pages, I think.
I'm considering doing an addendum stream when I actually read because I actually want to see how relevant the cases that he cited are to this document. I actually want to see that. Good. So when I do read that and I have a stream, I'll definitely crank it up and then invite you guys or something. Yeah.
Yeah, it would be funny because I'm wondering sometimes when I don't look up these cases, if these lawyers just throw random cases in there and hoping the judge doesn't see.
Let's hide that thing. Yeah. Who knows? The trial court's error of law on the first point is fully dispositive of this entire appeal. Statement of case and facts. It goes on to say most points in this appeal involve legal errors which are subject to de novo review. Although Laura disputes many of the trial court's factual findings, she recognizes the court will generally defer to the trial court's factual findings, but review de novo all legal conclusions. Thus, plentiful and egregious factual mistakes, notwithstanding, factual errors are not the primary focus here. With those standards in mind, Laura offers the following background of facts for context. And then he starts with Laura's pregnancy claim of May 2023. So he wants this all to start again, basically, which is what the novel, I believe, is for, because the novel means of new, isn't it? So I guess he wants a refresher after these legal errors has been resolved by the court, I'm guessing.
Well, I think the fundamental thing is that on appeal, they're basically arguing matters of law and matters of procedure, and they are not considering the factual relevance of the testimony and evidence in the original case. So they can't say, well, here's some new facts about the case, or these facts were determined to be wrong or something, so we're going to bring it up now. They're not bringing new evidence into the case. They're just arguing the procedure and the law around the original hearing.
I don't think that's going to go well for Gingras, but
Yeah.
The interesting thing, but you are correct. He does a little recap here, and it's interesting to read from the perspective of what does he include compared to what does he leave out.
I can't wait to start.
He's very selective, right?
And when I dissect like any article on my channel, I look at what they're telling you, but what aren't they telling you? Yeah. And this will be an interesting little, what aren't they telling us?
Yeah. And to be fair, you can't recap the entire case in 16 pages. On the other hand, by doing this little recap, he is selectively picking details that he wants to pick.
No.
Conveniently,
yeah. So continuing on, one sec. Let me just go on to the. So it doesn't say in her Laura's pregnancy claim, May 2023. In her establishment petition, and later in her trial testimony, petitioner and appellant Laura Owens claimed that on May 20th, 2023, she had a brief one-night sexual encounter with respondent appellee Clayton Echard, Clayton quote unquote, and in parentheses. 11 days later, Laura learned she was pregnant by taking a home pregnancy test, or HPT. There is a key information in here that has been left out already, but
he's committing a logical fallacy here. Like, if you're pregnant, you're probably going to pass a home pregnancy test. But if you pass a home pregnancy test, it does not necessarily mean that you're pregnant, because there are other ways to pass a home pregnancy test. So this is a logical fallacy that he's committed here.
Well, also, I'm sorry, from someone who's been pregnant and worked actually on trying to get pregnant, 11 days is just...
that's another good point. The timing is very interesting.
So it will, if anybody on the appellate court is a woman, a mom, that one will, because 11 days, you are less than 2 weeks pregnant.
Oh boy.
That's not how this works.
My understanding is that there
are people who go.
The appellate judges here in Tucson are not women. Maybe there's one or something, but I don't know who's assigned to this. So they'll create a 3-panel judge, I guess. I think it's unlikely that there will be a lot of women on the panel, unfortunately. But who knows?
So basically, essentially, you guys are saying that he is hoping for a male-only panel that will not see through the.
Well, I don't know what he's.
BS.
If I were him, I would not have put 11 days.
Yeah, exactly.
I would have left that out.
It's a red flag for sure. I think he has said he likes the Tucson venue better than the Maricopa or the Phoenix venue, because he thinks those judges are less likely to have heard of this case or something, or I don't know.
And in that respect, I can agree with, because there is a lot of, it's always nice if you get someone who doesn't know anything, who can be objective.
That would be good, yeah.
But at the same, and make it clear that I don't know anything about this case. This is, hundreds of miles away, or, but at the same time,
Yeah, they have to perform their objectivity with due diligence. Like, hey, 11 days to know you're pregnant, that's a red flag, right? Like, yeah, hopefully.
And I'm not going to assume, but one would think that even the men who, a lot of these appellate judges are older because they had to work their way up. So for them to not be parents or grandparents by this time and not have any sort of idea how a pregnancy actually works.
It's unlikely.
We'll see.
I don't know. Like, I thought I knew a lot about being pregnant, and then I got pregnant, and I realized that I had absolutely no idea about being pregnant.
So for someone,
luckily with the appeal, the panel can focus on the procedural aspects and the legal aspects, which, they don't have to be medical doctors, I think, to do that.
I don't know. I don't know. I feel like for this case, because Squid, you made a good point there, like that you got to understand that you didn't know much about pregnancy until you actually got pregnant. It makes me think, if Laura actually does get pregnant once in a while, she might actually understand that what she's been putting out so far has been maybe
yeah.
Oh, you really need to sort out that cough, Squid.
Sorry, I've been sick lately. I apologize.
Laura saw medical confirmation of the pregnancy the next day at a Banner Urgent Care facility in Scottsdale. The pregnancy test at Banner Urgent Care was positive. On June 17th,
if you get a positive HCG test, you can go the next day and get another positive HCG test. The tautology is sound.
Well, here's my thing. Usually when you go get a positive test at a place, it's blood. They don't test your urine, they test your blood.
Yeah.
Also, if she has this many medical conditions, epilepsy, among other things, why'd she go to an urgent care and not her primary care doctor?
Right. Exactly.
Good point. I didn't know that. Good point. That's a very good point.
This also working in a hospital for 6 years, glad
to have.
Like, I imagine my primary care physician, who I see all the time, would refer me to an OBGYN to see all the time.
That's generally how it works. You go to your doctor, and if your doctor can't do something, they refer you to somebody who can.
They give you a referral, and then you have proof of the referral because it's all coded and all that jazz. Yeah.
Yep.
Learning something new every day.
This just came to me. In all of this, she's managed to mention all these specialists, but she's never once mentioned a primary care. But to have epilepsy and to get all these meds, you need a primary care doctor. Because your specialist is going to say, go to your primary care doctor and get labs, or go to your primary care doctor and get this.
Yeah, that's where you're getting a physical every year, especially if you have these ongoing health conditions.
In all of this, I just now put that together.
Wow.
And how long have we been talking about this case, and I just now realized that?
Yeah.
Okay. On June 17, 2023, Clayton invited Laura to his home in Scottsdale to discuss the situation. When Laura arrived, Clayton, doubtful of Laura's pregnancy claim, surprised her with a home pregnancy test, which he insisted she take immediately in front of him. Laura took the test Clayton provided. It was positive. Trial court. Hold up. The way that he's arranges this. Okay, let me read this. EP5 trial court finding or meeting he referenced. Okay. Clayton provided a pregnancy test for her to take. Both parties agreed the test was positive. Emphasis added.
Yeah.
I don't know. Okay.
So much to say.
Also, in hearing about some of the details of the depositions and so forth, I'm not sure it was entirely a surprise. Like I actually thought I heard like she knew about it over text messages before actually being at the location of his place. So I'm not 100% sure on that. So that one is another red flag to me because I'm not sure how accurate it is. I mean, if you get a text message and you're surprised, I guess you're surprised, but that's different than going to a location, walking in the door and being surprised. These are two different things. And I'm not sure which one actually occurred.
Okay.
Well, and both parties agreeing the test was positive also doesn't mean that she's pregnant. It just means
because it's another HCG urine test. Yeah.
And I believe, and I could be wrong, I can't exactly remember what I did, but I believe I looked up some of the medications she had mentioned, and I Googled this, or I looked up the side effects, and one of them was an increase in HCG.
There you go.
So there could be a lot of things to consider.
There's a myriad of possibilities, and until you sort of exhaustively somehow rule them out, which I think is impossible in this case.
But she never reports having a blood test for pregnancy. She never, ever reports having a blood test. Every test she's ever taken has been urine.
Yeah, until she got the really low numbered one later on.
That's true.
That was a blood test, but that wasn't at the beginning, from what I understand. That was near the end. And then she, of course, altered a copy of that and sent it to Dave.
Yeah, that's another thing. Like,
kind of ridiculous.
What is with lawyers lately just being so like there's reasons people hate lawyers, and this is one of them.
Yeah. Also, don't forget to hit the like button if you're enjoying the stream so far. Do those fantastic YouTube things. But yeah, back into the reading. So he says Clayton later confirmed seeing the positive test in an email entitled "Something to Consider," which he sent to Laura a few days later on June 21st, 2023. In that email, Clayton made several admissions about the pregnancy. This is the email. Well, this is the excerpt from the email saying, even after seeing a positive pregnancy test, I still had doubts in my head. Something was telling me to look deeper into things. So I did, and came up with a theory that could potentially be realistic. Considering you only performed oral sex on me and no vaginal penetration occurred, the chances of you being pregnant seem considerably low. Although, again, so what were you guys saying before we what were you guys
about the viability of how long Clayton's stuff can last outside the body and have viable ability to get someone pregnant?
Yeah,
I want to say it's only like 45 minutes outside of the male human body. Does it actually like last?
Yeah, I don't think it's many hours.
But it was oral sex though. Like did it fall from the mouth and then
she didn't completely do her job, or it was some stuff leftovers.
Thanksgiving leftovers.
Deal. I'm trying to like not be a 12-year-old. Even if there was some extra material, like the timeline doesn't seem to add up for it to be medically viable.
Right. Because if there were oral arguments and then there were some leftovers and then hours and hours went by and then there's some grinding and another set of oral arguments, I don't see how you impregnate someone. But in any case,
I mean,
it's not really what the appeal is about, but
I don't know. He brought it up. He brought it up.
I know.
Well, we did kind of say that we were going to pick apart this.
He's doing a recap. Yeah.
He could have stuck to the oral arguments, but
oh boy.
Okay, so going on, he says, He says Laura and Clayton discussed the situation over the next several weeks, but could not agree what to do. Another positive HPT on August 1st. Laura filed her establishment petition later that same day. Litigation begins. Scene B. I'm gonna call these scenes rather than
episode 2
and action. After 2 months of unsuccessful private discussions and multiple positive pregnancy tests, on August 1st, 2023, Laura filed a petition to establish paternity. On August 21st, 2023, Clayton filed a response denying paternity. From the inception of the case and for months to follow, both parties were pro se. In September 2023, Laura and Clayton agreed to submit samples for DNA testing through a company called Ravgen. A Ravgen representative later indicated the tests were inconclusive. I wonder why, because there was little to no fetal DNA found, quote unquote. Thus, there was insufficient genetic material to establish or exclude Clayton as the father within the 95% certainty requirement of ARS 25-807D. Bad news arrived a few weeks later. On October 16th, 2023, Laura had a blood test which showed her HCG pregnancy hormone levels were 102. Although this test confirmed Laura was still technically
What?
I'm sorry.
I don't know about that.
It's a word technically there. He just slid that in there as if no one would notice anyway.
Oh boy. This guy seems to think that anybody with a HCG test above 4 is just pregnant, and you can't argue that they're not pregnant. It's big red flags for sure, yeah.
Yeah. Just, from someone who's, you see those little legs right there? From someone who's done this. Actively done this.
Oh gosh. Again, they better hope that there's not a female appellate judge up there after reading this.
I mean, because regardless of the procedures and the rules of procedure that I know the appellate court is only looking at, a female judge is going to look at this and be like, this is already bullcrap. Like, what else are you what other bullcrap are you trying to introduce? Because
yeah, it definitely doesn't build trust or credibility. That's for sure.
Oh, okay. I accidentally clicked on one of his links, so oh
boy,
I lost my way. In September 2023, Laura and Clayton agreed to submit samples for DNA testing through a company called down there already. Yeah, and here we are. On November 14th, 2023, Laura saw a medical provider at MomDoc, an OBGYN facility. At that time, Laura was given 2 pregnancy tests, both of which were negative, confirming her pregnancy had failed. No.
Or it could mean you were never pregnant to begin with.
And she was no longer pregnant as of that date. Go on.
Again, he's speculating on the answers and leaving out other potential alternatives that have not been scientifically ruled out. This is a failure of science on his part in writing this document.
This is a good story. I'll give him that much. Yeah. This is a good, if you're writing a novel or a Lifetime script, this isn't Hallmark material. This is more Lifetime. Crazy woman, allegedly.
100%, yeah.
This is, none of that makes sense. And wait, and here's another thing that, just October 16th is when you had the HCG test, but you waited till November 14th to see anything, to see anybody, to see an actual provider.
It's another big red flag for sure.
As a woman, this insults me.
Yeah.
It's insulting to think that you would think that people are this stupid.
Yeah. Absolutely.
And it's quite frankly insulting to anybody who's tried to get pregnant and couldn't.
Yeah.
Absolutely. Absolutely. After learning of the miscarriage in mid-November, Laura, who, let me go back and read, confirming her pregnancy had failed and she was no longer pregnant as of that date. Let me just put that out there. That they actually said this rather than anyway. After learning of the miscarriage in mid-November, miscarriage. They never said it was miscarriage. They said it was a negative test. It wasn't
Yeah, he's speculating hard here.
And I'm sorry, at 25 weeks, a pregnancy is viable. So she's at 7 months. So she's at 28 to 30 weeks. That would be a viable pregnant, like that would be a viable body that you need to remove.
Right.
Not tissue that passes.
Yeah.
That's
so clearly that didn't happen.
So basically, what you're saying is a C-section would accompany this test, correct?
Yeah.
Oh gosh, but then again, like I said earlier, Laura would need to go through pregnancy to actually understand this. And if she hasn't gone through it, then she's not going to understand what is being said here. After learning of the miscarriage in mid-November, Laura, who, like Clayton, remained pro se, filed nothing in the case. She pursued no discovery and otherwise had no case-related contact with Clayton. Due to inactivity, on December 4th, 2023, court administration notified the parties that the action was scheduled for dismissal. After receiving the notice of impending dismissal, Laura filed nothing further and took no action to keep the case active. However, before the case was dismissed, Clayton retained counsel Greg Woodnick Esquire, who appeared and immediately filed pleadings seeking to avoid dismissal. First on, go on.
Because this is the part where it's interesting what he leaves out. You know, he leaves out that she's writing Medium blogs about Clayton. He leaves out that she's calling the Scottsdale police about Clayton. He leaves out that she's doing the order of protection against Clayton in a completely different case where they both have to eventually retain counsel. He leaves all this out.
So just fun facts, at 28 weeks pregnant, your baby is approximately 14 and a half inches long and 2.5 pounds.
Yeah.
That's average. Yeah. So nowhere did she say ever passed piece of tissue that was 14 and a half inches long.
So clearly that didn't happen. And my problem with this whole thing all along has been, let's give her the benefit of the doubt and say she was pregnant and she had a very, very early term miscarriage. It doesn't explain all her actions. It doesn't explain her large belly in the Zoom court hearing calls for the orders of protection. It doesn't
saying
give
I'm
her
100% pregnant.
Yeah, exactly. It doesn't give her, if this literally happened, she was pregnant and had a very, very early miscarriage. She was in this she sought paternity determination with insufficient evidence. And in my mind, she should pay the bill for that.
Yeah, I agree.
Mine too.
I agree. Okay, so hold up. So moving on. First on December 12, 2023, Mr. Woodnick filed a motion for leave to amend Clayton's response to the original petition. Next on December 13th, Mr. Woodnick filed an expedited motion to extend the dismissal date and a request for an evidentiary hearing. Just days later, on December 22nd, 2023, Laura retained counsel of her own. 6 days later, on December 28th, 2023, Laura moved to dismiss her petition with prejudice, explaining petitioner is not now pregnant with respondent's children. Here, there is no paternity or maternity to establish, as petitioner is no longer pregnant. Accordingly, to this case must be dismissed, quote unquote. Emphasis added. On January 3rd, 2024, after Laura moved to dismiss her petition, Mr. Woodnick filed a motion for sanctions. In his motion, Mr. Woodnick claimed Laura violated family law rule number 26 by filing by filing the establishment petition without medical evidence, quote unquote. Petitioner filed the underlying action of an improper proper purpose without medical evidence to support a claim that she was pregnant and or that she was pregnant by respondent. Petitioner could not have become pregnant from the limited encounter the parties had, and therefore premised this entire action on a fiction. Petitioner violated Rule 26B 1 to 3 in her petition and subsequent filings. Immediately following the Rule number 26 motion, the record becomes a confusing and contradictory mess. To begin, on January 24th, 2024, the trial court issued order granting Laura's motion to dismiss. In that dismissal order, affirmed for a second time the next day, the court indicated petitioner advises she is no longer pregnant and has filed a motion to dismiss. While the court will grant a motion, the issue of the sanctions and attorney fees remain, quote unquote. On February 2nd, 2024, the trial court issued a new order setting an evidentiary hearing regarding the issue of sanctions and the attorney fees for February 27, 2024. So all of this shortly before the original hearing date, which was later continued until June 10th, 2024. On February 21st, 2024, the court issued a new order denying Laura's motion to dismiss, despite the fact the dismissal motion had previously been granted twice a month earlier. So he's basically saying that all of this, that this case has been dismissed already, and this is basically error. But
well, I think it's more subtle than that, because there are issues within the case and they're ruling on issues. So they're ruling on sub-issues, and you can approve or deny sub-issues within the case. So there's really no contradiction here. And in terms of the case docket being confusing, that's on him, because I can go to the docket and pull all the filings, and they're all in temporal order, and it makes sense to me. So if he's confused, that's his problem.
I admit the timeline is a little confusing. However, when you actually look at the docket or anything that's been made for the timeline, it's pretty easy. Just talking about it, you mentioning different dates and different times and different events, it can be confusing. But if you actually look at the docket, which he has access to, it's not confusing.
Yeah.
Yeah.
And so they can dismiss any actions that are relevant to the paternity determination, which is fine. But then they have the issue of fees and sanctions, which they still have to figure out. So they can rule separately on that. So to me, it's not, I mean, I'm not a lawyer, but to me, it's not confusing or contradictory.
And I would say if it's not confusing to lay people like us, then it shouldn't be confusing to someone with a law degree.
Good point.
Absolutely. Matters then became even more convoluted and confusing. First, on April 3rd, 2024, Clayton moved to withdraw his Rule 26 motion. After more than a month passed by without any decision from the court on the request, May 10th, 2024, Laura filed a motion for judgment on the pleadings, asking the court to deny Clayton's still pending Rule 26 motion as a matter of law. The motion argued that because Clayton failed to comply with the procedural requirements of Rule 26, sanctions were unavailable under Rule 26 or any other authority, such as the court's inherent authority. The motion also renewed Laura's request to dismiss the action since there were no other issues for the court to resolve. On May 16, 2024, the trial court issued an order granting Clayton's request to withdraw its Rule 26 motion for sanctions. That order did not, however, resolve Laura's request for judgment and on the pleadings, nor did the court mention Laura's renewed request to dismiss her petition. About 2 weeks later, on May 28, 2024, the court issued yet another confusing order, explaining that due to a clerical error, the court had intended to issue a ruling on Laura's motion for judgment on the pleadings, but due to those undescribed error, the court's decision was not remitted to the parties. The court discussed various arguments raised by each side on the question of whether Laura could still be sanctioned, given that Clayton's Rule number 26 motion was withdrawn and no other sanctions were pending. No other sanction motions were pending. Sorry about that. Inexplicably, the court concluded Laura's legal arguments regarding sanctions were moot. Therefore, let the record reflect the court declines to take further action. I don't know why he wrote that in all caps, but anything for the drama, I guess. Anything for the drama.
Are you sure he's a lawyer and not a screenwriter?
You might as well. I mean,
it's not, if he finds it inexplicable, he can file a motion. You know, there's remedies for everything he's talking about here. And it's not the appeals court business why the petitioner's side didn't file things that they could have filed in terms of remedy.
You know, come on, his only remedy is his blog and Twitter.
Oh boy.
Like, come on.
Yeah.
Like, let's be honest here. And now YouTube.
Yeah. Once he realized no one would go to lunch with him, I guess he had to start a blog, right? Yeah.
Like, how dare you assume that a lawyer could file a motion to, take care of his issues? That's what Twitter is for.
Right. Yeah, Twitter.
The core public opinion, of course.
When no one will go to lunch with you, you got to fire up Twitter. That's the solution.
To recap. Okay, so scene 3, recapping and action. Okay, at the end of May 2024, Clayton's Rules number 26 sanctions motion was withdrawn. The court ruled that the issue of sanctions was moot and no other motions remained pending. Despite this posture and with nothing left to decide, the court still held an evidentiary hearing on June 10th, 2024. Following a 2-hour hearing on June...
It seems like there was something to decide.
If you had to talk for 2 hours and it could have been all day, there was definitely something to decide.
I know, right? Wow.
I mean, that's just me. But I can talk for 2 hours by myself, so yeah.
He's just speculating again here. Like, okay, there was nothing to do, nothing to see here. Everybody go home. Like, come on.
Following a 2-hour hearing on June 18, 2024, the trial court issued a lengthy 19-page decision which contained... 19 pages is not lengthy. This is lengthy. Okay. This is lengthy. I'm sorry.
I don't mean to interrupt you, but his words of lengthy 19 pages. Dude.
This is a 75-page appeal brief. I mean,
does he get paid by the word?
Maybe. Also, lengthy is very subjective. Like I don't know. Like, luckily he puts 19 pages, but like, how does he get to say that's lengthy for this case? Like, what if that's what this case needs? Like, that's another subjective assessment that has no basis in scientific measurement.
I hate subjectivity. It's so like,
right?
I don't know.
And this document is full of it.
It seems like he thrives in subjectivity. Would you say he thrives in it?
I guess. I don't know.
Yeah. That's the only place he thrives. Actual evidence isn't his strong suit. Facts.
Following a 2-hour hearing on June 18, 2024, the trial court issued a lengthy 19-page decision which contained findings on the issues of sanctions, paternity, attorney fees, and costs. Many of these findings are either directly contrary to the admitted evidence or supported by no evidence of any kind. In the end, the court found Laura acted unreasonably when she initiated litigation without basis or merit. Without an authentic ultrasound, sonogram, physical examination, and in conjunction with a believed she passed tissue in July 2023. The court finds the underlying petition premature at best, quote unquote. I'm glad the authentic ultrasound made it in here somehow. I'm actually glad.
Yeah.
That's the worst.
It's just amazing how he says the findings have no basis in fact or whatever. I mean, that's a big claim, and you have to prove your claims, and I don't think he does in this document.
No, not at all.
Tell me you've never actually been pregnant without telling me.
Yeah.
Yeah. In the post-trial ruling, the court again recognized Laura's argument that Rule 26 sanctions were inapplicable because Clayton failed to comply with the procedural requirements of Rule 26. The court further noted a separate problem. Clayton's Rule 26 motion was withdrawn. The question thus becomes, can the court still award Rule 26 sanctions considering respondent's withdrawal of his motion, quote unquote, without allowing any input from the parties? The court held, despite the withdrawal of Clayton's motion and ignoring its failure to comply with the requirements of Rule 26 and contrary to his prior order, holding.
Well, they never argued whether they failed Rule 26 or not. They withdrew it to save time, not as an admission that they didn't do it properly. So he's framing it as an admission of failure when it never was.
Well, and I look at it this way too. Just because you take away or you withdraw a motion doesn't mean it wasn't actually there. It's like going to the cops and saying, she hit me, and then saying, no, she didn't. Well, you told the cops she did. They have to file a report.
Right.
Like the cops still have a certain due diligence, even though you want to take back what you said.
Mm-hmm.
You can withdraw a motion, but the original motion is still in the court record, which gives the court.
Yeah.
You can say, I don't want to do that anymore. Like, I don't want to press charges, but that doesn't mean that charges won't be pressed because the ball was already rolling.
Exactly, yeah. There could be other remedies, and he's completely ignoring the other ways you could get sanctions in this case around this Rule 26 motion, which I think is what that'll probably show up in the response.
Yeah, like I said, I can't wait for that response. I hope it's as scathing as
yeah, we'll see. I mean,
I hope it's as scathing as Squid Pro Quo's reply to maybe it's my internet. It's probably my internet.
That's happened to me before.
Hopefully that does help it, and hopefully it does make it not so choppy. But that's the best I can do. Okay. All right. Let's continue on with the reading. Immediately upon discovering this extremely serious misconduct by the trial judge, Laura filed.
How does he know it's misconduct? It's not his place to judge.
But he's always right,
Yeah,
I guess.
He's a judge, jury, and the executioner too. So
yeah.
Don't mention that last part. I mean, he did a few shady things on YouTube, so
that's true.
Let's not.
Oh boy.
Oh my god.
Any of us would have been muted.
Laura filed several pleadings, including a notice of change for judge for cause, supported by an extensive affidavit of counsel. Laura also moved to vacate the judgment, moved for a new trial, and moved to alter and amend the judgment. Simultaneously, Laura also reported these matters to the Commission on Judicial Conduct, which opened an investigation which remains ongoing as of the date of this brief. As of the date of, he's missing a word. As of the date this brief, it's missing a word.
Oh,
it's missing a word. It's supposed to say as of the date of this brief was filed. as of the date this brief was filed. Okay, maybe I'm not reading it properly.
It's a big document. We'll give him one typo.
No, that makes grammatical sense to me. It's either which remains ongoing as of the date of this brief or the date this brief was filed. But I think he needs a comma.
Okay.
Yeah, something, because it threw me off. He needs something in there. It threw me off completely. Anyway, enough about
That'd be
On July 18, 2024, despite having no authority to do so while she was subject to a pending notice of change of judge, and before Clayton filed any brief opposing the motion, Judge Matter denied Laura's new trial motion and her request for other relief. Several days later, after this apparent act of retaliation was reported to the Judicial Conduct Commission as a violation of Commission Rule 14, prohibiting acts of retaliation by judge in response to a complaint to the Commission. Judge Matter issued a new order withdrawing her prior order, claiming she was unaware of the notice of change of judge that would suspend the court's authority, even though the notice of change of judge was mentioned on the very first page of the motion for a new trial she just denied. I don't know how factual that is. Okay. Go on.
For some reason, I don't think he's accurate with that. I think his timing is off. And there's also a difference between the date it's given to the court and the date it's filed.
Put on the docket, yeah. There could be a pipeline of different things going on here with all these filings. And
but he assumes
if the judge
that might have messed up.
If the judge is working on some things and the clerk of court is working on some things and the judge's assistant is working on some things and all these things are happening in a pipeline, you can have these cases where you get a little bit ahead of yourself and it's just administrative. It's not retaliation. He just jumps to the assumption that it's an apparent retaliation, which, I don't know, there's no evidence of that. It's just speculation again.
Okay.
I don't know. It's all speculation.
Well, yeah, all speculation. I hope I have tried to move the antennas around, so hopefully the internet is a lot better. Maybe it's the position I'm placing it in. Okay. Hopefully it's fixed now. Hopefully. Anyway, moving on. So on August 13th, 2024, the presiding family cause judge, Honorable Rhonda Fisk, denied Laura's notice of change of judge. In our order, Judge Fisk recognized Laura correctly points out that Judge Matter's July 7th ruling contains a factual error. The transcript from the June 10th hearing shows that Dr. Samantha Deans did not testify that Planned Parenthood is not open on Sundays. Despite this, Judge Fisk concluded the evidence failed to show Judge Matter independently investigated the facts. The courts find Laura relies on mere speculation and suspicion when alleging that Judge Matter engaged in a secret, undisclosed investigation and therefore is biased. Despite this, Judge Fisk could not explain and did not explain how Judge Matter could have probably found Planned Parenthood is closed on Sundays, since no trial testimony or evidence addressed that issue. Why is this? I've got to ask, why is this issue so important for them that they must die on this hill?
Well, I mean, they need to file an appeal, and so they'll find any, thing to grasp to get their appeal going.
And it could be an easy error on her part because so many people testified, and she might have known that information prior for any number of reasons. And generally, I'm sorry, but generally non-hospitals, non-emergency medical facilities are not open on weekends. It's not hard to it's not hard to fathom that.
Mm-hmm.
Anybody who's ever been to a doctor, tried to make an appointment on a weekend, it doesn't work. If you're not an emergency, or an urgent care, they're generally not open on weekends.
Okay.
And Planned Parenthood is just a glorified doctor's office. It's not an emergency facility.
Yeah.
Fair enough.
And it's interesting how he says Judge Fisk can't explain. I mean, certainly they didn't explain, but the notion that they can't explain, like you could subpoena people, you could start investigating. I would be interested in the answer to the question, but even without the answer, I don't know what to do with his appeal. It doesn't it doesn't rise to the level that I think it's important enough to care about.
Yeah. Judge Fisk ultimately brushed that concern aside, concluding the question of Planned Parenthood's business hours is little or no importance given the rest of the findings in the. This is Judge Fisk, by the way.
It's interesting how he says. It's interesting how he says a judge's judgment in doing their job is just brushing something aside. Like, okay, like, what a dismissive way to talk about somebody doing their job.
You know what I mean? Another woman.
Yeah, exactly. Like, he spends a lot of time like sort of disparaging, you know, Judge Mata, Judge Fisk, Deandra, doing cross-examination. He's very dismissive to women.
Like,
sounds familiar.
I still can't get over the inexperienced trial judge. I still can't get over that. Okay. After Judge Fisk, after Judge Fisk denied Laura's notice of change of judge, she authorized Judge Mata to rule on any remaining issues. This resulted in the court granting Clayton's request for fees, costs in a judgment entered August 19, 2024, and denying all of Laura's post-trial motions for a second time. This timely appeal followed as explained in Laura's notice of appeal and her amended notice. This court has jurisdiction pursuant to ARS law numbers that I cannot read out in sequential order, and if needed, Barresi versus Madsen. These are just some cases that he's citing. So, and these are the issues that he says the trial court aired for the appeal court to remedy. I'm guessing is why they're there.
Yeah.
So, as a matter of first impression, when a party files a motion seeking sanctions for an alleged violation of Family Law Rule 26, but that party does not comply with any procedural requirements of the rule and later withdraws the motion, may the trial court nevertheless award Rule 26 sanctions to sponte in a manner that wholly ignores the procedural and safe harbor requirements of that rule. And assuming sanctions were unavailable under Rule 26, did the trial court err by sanctioning Laura for a Rule 26 violation using its inherent authority or law? That just, I don't know. That sounds like he's making it up. I don't know about you. That sounds like he's making it up. You guys all right?
Yeah, I don't disagree.
Yeah, I mean, I don't know. I mean, he can always ask the question. It's just, you know, if all of this was set before June 10th, in terms of we're going to have a hearing to determine whether there should be fees or sanctions, to me, it was already all done. Like, they were going to have a hearing. He complains that there was nothing to rule on, so why was there a hearing? But clearly there was a hearing. That's a historical fact. The judge wouldn't have had it unless the judge had a reason. If he didn't like the reason, that should have been hashed out in filings before June 10th. Instead, he's trying to hash it out here or get a second opinion here. I don't know. It just doesn't seem useful to me.
I don't think that the judge would have wasted her time with all of this chaos if she didn't have to.
Correct. Yeah. That's a more succinct way to put it.
Straight to the point. You're more eloquent with words than I am, but somehow just
hit it on the
tell
head.
it like it is. You're way better with words than me.
We can figure it out.
Are you saying hi?
Cute, cutie.
My social media manager.
All right.
She runs my channel. I just live here. Let's be honest. Okay.
Issue number 2. Did the trial judge commit structural error entitling? Gosh. Once again, thank you so much for everyone that's here. Apologies for the connectivity. I hope that it has gotten better now, hopefully, but I'm doing my best on my end to like mess with the settings. This is pretty much new to me.
Okay. Hopefully the replay will be smooth. We'll see.
Yeah, hopefully the replay will be smooth. Issue number 3. Did the trial court by awarding sanctions under ARS 25324 and or 225-415 when there was no basis for such an award and no motion for sanctions under those statutes was ever filed? Issue number 4. Did the trial court err by awarding legal fees of $1,550,000 when the alleged misconduct did not cause the fees to be incurred? Issue number 5. Is Laura entitled to attorney's fees and costs on appeal? So yeah,
no.
No. Straight up no. And this one is gonna make legal arguments for all of it, and the rest of this are legal arguments for those issues that was raised. So well, what did you think of the Avengers Endgame script written here by David Ingris?
I wouldn't go that far. I would more say like Minions.
Minion.
Or Wreck-It Ralph, as far as script writing goes. I mean, it was hard to follow, so maybe a little bit of like, yeah, it's more Barbie to me.
Student filmmaker.
Don't go as far as the Avengers, because that's not a great script, but it's like, this is, I don't know. It just screams toddler mad that I lost.
Wow.
Yeah, because he literally repeats the same thing he did before in other documents, just emphasis added, or like brings up things that Judge Fisk already concluded. So he's not saying one trial judge messed up, but 2. And like you're appealing something you literally already appealed. I mean, even though technically that wasn't an appeal, it might as well have been. Oh, did we lose? There we go.
All right. Okay. And okay, so what do you think? What do you expect? This I'm just gonna throw this question out there. What do you expect to see on the response to this filing? Because I can already envision a couple of things in my head. What do you guys expect to see? I'll start with you, Bruce.
Well, I certainly hope they take his, he has sort of 5 problems or 5 questions, I guess. They're not all really, some of them are more statements than questions or problems, but he has 5 points, which I think is good. And I would like to see just a very fact-oriented, law-oriented response. Omar Serrato, the tilted lawyer, went through and he found a number of cases that appear to be far more in support of the respondent's case than the petitioner's case. And, he only spent an hour or 2 doing that. So given that they have, 30 days or whatever it is to do their response, and they're already have been planning to work on this response, I expect to see a very clear, concise takedown of each of his 5 points, with the one about the fees and sanctions being the most in-depth.
Okay. And yourself, Squid?
I don't disagree with that. The only thing I would add is that I think they've had their response pre-written for a while, and they already knew what he was going to complain about. He's been complaining about when you put your whole life on Twitter, people already know what you're going to bitch about.
They've probably been able to do quite a bit of pre-work. I agree.
Yeah. And I think that all they have to do, so I don't think it's going to be a full 30 days before they respond. I think it's going to be relatively soon because they knew a lot of this was coming, and all they have to do is tailor it. I think they had a lot of their legal arguments already ready to go.
Mm-hmm.
So
they may wait till the end of the deadline just to make sure that they get as many eyes on it, get as many review cycles on it as they can. If anything happens, in the case, in the meantime, they want to be able to see it and understand it. So I think they might wait until the deadline just for those reasons, not because they're busy doing the work.
That's true. And who knows, maybe they're careening social media, and when they see people talk, they get ideas. They wouldn't be the first legal team to do it.
Right, yeah.
When you hear people talk about, and especially LawTube, you have other lawyers talking about it, you're basically getting free legal consultations. So you hear what they were going to say, and you're like, oh, I never thought of that. But let me just look into that a little bit more and kind of not allow YouTube to do some of the work for you, but brainstorm things that you might not have thought of yourself.
Okay.
Yes.
Okay. And just like that, I'm gonna bring this stream to a close. By the way, what do you guys think of before I do bring it to a close? I just want to ask: are you guys looking forward to David Gingras and Laura's new podcast that they are starting starting up very soon? What do you guys make of that?
Oh, that's even more. It just seems like everything that happens with this case just becomes like chaotic. So, I mean, my understanding is they went to a podcast studio and recorded some material, and it may be that they didn't get the footage, or the footage didn't have good audio, or there were some problems with it, or, there may be drama with the studio. So I don't know what they're going to do, if they're just going to record more Zoom calls on his YouTube channel or what. But I don't know. For me, I just can't listen to the guy anymore because it's all just sort of this speculation and jumping to conclusions or insulting people. And I'm sort of done with it. He needs to apologize for the terrible things he said about special needs people. He insulted a special needs mom. He insulted Dave Neal. He, talked about Dave Neal's family in disparaging ways. I think he needs.
Fine. They put themselves on the internet. They open themselves up to people not liking them. However, no matter what, families aren't YouTubers. Like Dave Neal is a YouTuber. His wife sort of is a YouTuber, but his child is not a YouTuber. Like Megan's kids are not YouTubers. Like, leave families out of it. You want to talk crap about like the YouTuber that you don't like a video they made? You do you, boo-boo. But like, when people bring up families, you automatically lose credibility with anything else you're saying. Because I'm petty, but I ain't that petty. Like, even I have my limits.
Well said. Well said. Oh gosh. And just like that, I'm gonna bring it to a close on that note. On that note, we'll bring it to a close. I'm all over the place today, but yeah, I appreciate both of you guys for joining me today. Thank you so much, Squid, for joining me. You can find. I am gonna put the on and also Bruce for joining me as well. I'm gonna put both of your channels in the description so that people can go check and can go check you guys out. But yeah, like are there any content that people should look out for? We'll start with Squid with you, Squid.
I'm doing a deep dive for anybody that hates government corruption. I'm doing a deep dive every week on where our tax dollars go and what's in our food while trying to keep my videos monetized.
Wait, do they like shadow ban? I'm not sure if it's called shadow ban, but do they limit ads? What's it called? Ad limiting. Like, do they limit ads on videos like that?
They haven't on mine so far, but other people have had their streams taken down. So I'm walking a very fine line of how to approach these topics on a YouTube friendly, non-medical misinformation type of way.
Oh, I see. So that's how they do it. Okay, I see. And what about you, Bruce? What you have coming up?
Well, every Tuesday I'm dropping a new video about management best known practices, whether you're managing a team in tech or some other group dynamics. So I'm doing a regular series there, and then other videos around whatever I want in the meantime.
Okay, perfect. That sounds exciting. And yeah, and also don't forget to tune in onto this channel's Unintentional Juror podcast this Sunday. We are going through we're going through a case of was it New Jersey versus Kalesko? I always get the name wrong, but it's a case where a family where a mass murder happened, and the family I'm forgetting the details. I'm blanking out again. But yeah, but I'll post the details on the community tab for you all to see. Thank you so much, everyone, for tuning in. Take good care of yourselves and have a great, and hopefully you have a great week. Take care. All right. And also, I know that it's across the pond. We don't really do it here, but is it happy Thanksgiving? Happy Thanksgiving.
Yep.
Yeah.
That's
Thanksgiving
tomorrow.
It's tomorrow.
Mm-hmm.
Yeah.
Thank
So,
you.
yeah. We yeah. So both of you guys, happy Thanksgiving, and I hope that both of you enjoy your Thanksgiving, and anyone that is on that side of the world. Hopefully you guys enjoy your Thanksgiving. Take good care of yourself. Bye-bye.
Bye.